Hi, good afternoon, and welcome to our 8th life sciences session already. Apologies for being 1 minute late. Today's session, so we started these sessions, I think, in October 2020, so a year and a half ago. We started them during the COVID pandemic, and in view of lockdowns, we wanted to stay in contact with you, the audience, our clients, but they're here to stay. So today we will discuss in our 1-hour life sciences session a very particular topic on global marketing authorizations and the impact on regulatory data protection. And we will discuss a decision from the General Court, both from a substantive and procedural analysis. My name is Kirian Claeyé. I'm counsel at Altius. I will be presenting the background and the substantive analysis of the decision of the General Court. And I'm here today with my colleague, Philippe de Jong, who's a partner at Altius, also specialized in life sciences, and he will be dealing with the procedural analysis. I will give a short reference to the appeal that is pending with the Court of Justice. As for the background, this case is all about one active ingredient in a certain way, which is called dimethyl fumarate, DMF. Biogen, at least its predecessor, but Biogen eventually obtained the marketing authorization for a couple of originator products. The first product that is a DMF-based product is Fumaderm. Now, Fumaderm does not contain only dimethyl fumarate, but also monoethyl fumarate salts, a number of MEF salts. And it was indicated for the treatment of psoriasis. Now, the second marketing authorization, and that is the one that is the subject, the central issue here, is the marketing authorization for Tecfidera. And Tecfidera, contrary to Fumaderm, related to the single active ingredient dimethyl fumarate, not a combination with monoethyl fumarate salts, and it was indicated for the treatment of multiple sclerosis and not for psoriasis. Now, back to the future, how did this marketing authorization for Tecfidera come to happen? On the 8th of June 2011, Biogen submitted a request to the European Medicines Agency for eligibility for the grant of a marketing authorization for a new medicinal product, which was going to be Tecfidera later on, under the centralized procedure. And Biogen explained at that point in time a couple of things. First of all, it said dimethyl fumarate is an active substance that has previously never been authorized as a mono product. Biogen added that it intended to submit full data, a full application for a marketing authorization under Article 8.3 of the Directive 2008/83, the Community Code, with all necessary data, including preclinical tests and clinical trials. Biogen explained that it was also the holder of the marketing authorization for Fumaderm containing DMF, dimethyl fumarate, and MEF salts. Now, on the basis of what Biogen had explained, it asked the European Medicines Agency to confirm that this new product, Tecfidera, would not fall within the scope of the global marketing authorization for Fumaderm, and that it would therefore benefit from a new regulatory data protection period, irrespective of whether or not dimethyl fumarate was classified as a new active substance. And this was actually the first time at an EU level that the question arose whether an authorized combination product, in this case Fumaderm, and the component of that combination, an active ingredient of that combination, in this case dimethyl fumarate, belonged to the same global marketing authorization. And to understand what is the impact of this global marketing authorization, it is important to look at the relevant rules. The concept of a global marketing authorization stems from Article 6.1 of the Community Code. The first subsection of Article 6.1 is that no medicinal product may be placed on the market without a marketing authorization. However, when a medicinal product has already received a marketing authorization, an initial marketing authorization. Any additional strengths, pharmaceutical forms, administration routes, presentations, variations, or extensions shall also be granted a marketing authorization or be included in the initial marketing authorization. And importantly, all these marketing authorizations will then belong to the same global marketing authorization, in particular for the purpose of Article 10.1 of the Community Code. So it refers to Article 10.1. And what does Article 10.1 tell us? First of all, if you apply for a generic product, you can do that with reference to a reference medicinal product. You do not need to submit new preclinical tests and clinical trials or results thereof. However, you can only do that after your regulatory data protection period has expired for the reference medicinal product. The regulatory data protection period, a period of 8 years, meaning that the product, the reference medicinal product, has to be authorized for 8 years already before the generic medicine can rely on the data of the clinical trials, preclinical tests of the reference medicinal product. Additionally, if you do that and if you use this route, you can apply for your marketing authorization on that basis after 8 years of the marketing authorization of the reference medicinal product, but you can only enter the market if 10 years have expired from the initial authorization. And there is even an additional paragraph that comes back in the General Court's decision, although it's not the central issue here, that you can extend this with another year for a new therapeutic indication, which is considered to have a significant clinical benefit. Now, this regulatory data protection regime is also embedded in Regulation 726/2004, particularly Article 14, as you see on the slide, refers to an 8-year period of data protection and a 10-year period of marketing protection, which is why we always use data protection and marketing protection to separate one from another as part of this regulatory data protection. And that can be extended to a maximum of 11 years. Now back to the facts. On the 3rd of August 2011, the European Medicines Agency, as I explained before, Biogen asked it to confirm that Tecfidera would benefit from its own regulatory data protection period, and the European Medicines Agency confirmed this. Because the marketing authorization for Fumadern was not the global marketing authorization, in its opinion, for the different individual active substances, dimethyl fumarate, the monoethyl fumarate salts, and also because a full development, a full-scale procedure was or would be followed by Biogen for Tecfidera under Article 8.3 of the Community Code. So this conclusion, according to the European Medicines Agency, applies irrespective of whether or not dimethyl fumarate can be qualified as a new active substance. In 2012, early 2012, Biogen therefore submits a marketing authorization application for the new product. And it includes all these necessary data, preclinical tests, clinical trials, and it declares that dimethyl fumarate was a known active substance. And it does not contest that it would be a new active substance. Or it does not try to state that it would be a new active substance. But the committee, after this application, renders a positive opinion regarding the grant of the marketing authorization, but it doesn't really explicitly stipulate and confirms that the regulatory data protection would apply. And Biogen therefore contacts the European Commission with the request that the decision to grant the marketing authorization for Tecfidera would explicitly indicate that a new regulatory data protection applies. Now, the Commission replies to Biogen that marketing authorization decisions generally do not include any statements on regulatory data protection. So it was difficult to actually meet Biogen's request. And it even added that it had reservations regarding the European Medicines Agency's earlier interpretation. The only statement that could be included in the marketing authorization that would be relevant for Biogen here is whether or not DMF, dimethyl fumarate, could be qualified as a new active substance. But this was not addressed by the committee, the CHMP of the European Medicines Agency, so therefore the Commission considered that it was not possible to make such statement. So it actually concluded, well, Biogen, you have two choices. You can either have a decision on the marketing authorization ground regarding the marketing authorization, but without a statement on the new active substance status of DMF. Or you request for an assessment, a reassessment of the new active substance status of DMF. Biogen chose the second option, and so the Commission requested the European Medicines Agency to assess whether dimethyl fumarate differs from Fumadern, which contains the two fumarates, and whether it is thus a new active substance. The Commission also indicates, and this is something that the European Medicines Agency will later refer to, indicates that a new active substance is a chemical substance that had not previously been authorized as a medicinal product in the European Union. So dimethyl fumarate was part of Fumadern, but was it authorized as a medicinal product as such? That was something that was going to be discussed. Biogen requests the European Medicines Agency to confirm that DMF classifies as a new active substance. After that, a number of reports intervene in the procedure. First, two reports, a report of the rapporteur, a report of the co-rapporteur of the committee, and they confirm in these reports that Tecfidera is indeed a different product, is a different substance from Fumadern, containing dimethyl fumarate and monoethyl fumarate. But they also asked the Quality Working Party, are dimethyl fumarate and monoethyl fumarate salts not derivatives from one another? In the joint report of the rapporteur and the co-rapporteur, they ask Biogen to explain this. Are they not esters or derivatives from one another? And or is there a potential significant difference in terms of safety and efficacy of these products between dimethyl fumarate and the monoethyl fumarate salts? The committee raises these 2 points as objections, and so Biogen responds on the 4th of November 2013. After Biogen's response, 2 things happen, and they seem to be at odds with one another. First of all, the rapporteur and the co-rapporteur file and publish their joint report, and they say that the data do not show that dimethyl fumarate's properties differ significantly in terms of safety and efficacy from Fumadern. So dimethyl fumarate can, in their opinion, not be considered as a new active substance. However, the committee, the CHMP, in its revised opinion, it had already published its earlier opinion, and now it's publishing a revised opinion. It recommends the marketing authorization grant for Tecfidera, and it adds that dimethyl fumarate is a new active substance, contrary to what the rapporteur and the co-rapporteur had already held. The Commission's decision, or the committee's decision, refers to what the Commission had earlier indicated, particularly that the new active substance is a chemical substance that had not previously been authorized as a medicinal product in the European Union. And therefore, because dimethyl fumarate differs from Fumadern, which contains DMF and MEF salts, it is a new active substance. As a result of that, there is a European public assessment report published with an explanation on the new active substance status of DMF. After that, there is a draft implementing decision of the Commission, but it is not over yet, because as part of the standing committee, a member asks for a plenary meeting. And that member actually states that on the one hand, he or she considers that DMF is not a new active substance given earlier use in Fumadern. But on the other hand, Tecfidera is covered by a new global marketing authorization because it's not an additional strength, pharmaceutical form, administrative route, or presentation of Fumiderm or an extension thereof, as under Article 6.1, second subsection. On the 28th of January 2014, there is therefore a plenary meeting in the Standing Committee. Most members agree DMF is not a new active substance, and there is an amendment to the draft Commission implementing decision, in which the new active substance status is deleted, but which adds that the application for a marketing authorization for Tecfidera is based on a full application with all necessary data, including preclinical tests and clinical trials for Tecfidera, therefore hinting at the fact that it would benefit from own regulatory data protection, or that's at least the support which the Commission tries to give for this conclusion. So the Commission eventually grants a centralized marketing authorization for Tecfidera after this entire discussion, and that is the so-called implementing decision. And in the implementing decision, the Commission states dimethyl fumarate is part of the composition of the authorized medicinal product, Fumiderm, belonging to the same marketing authorization holder. The Commission also concludes that monoethyl fumarates and dimethyl fumarates are both active and are not the same active substance since they do not share the same therapeutic moiety. Therefore, Tecfidera containing DMF only is different from Fumiderm containing DMF and MEF. And as a result of that, the marketing authorizations for both products, Tecfidera and Fumiderm, do not belong to the same global marketing authorization as described in Article 6.1 of the Community Code. The European Public Assessment Report is then amended, and it states that its earlier statement and that your earlier European Public Assessment Report on DMF as a new active substance is now obsolete in view of these comments in the implementing decision of the Commission. So it's a lot of information, a lot of back and forth between Biogen, the European Medicines Agency, and the European Commission, and one could say that it was perhaps an accident waiting to happen. And it actually also happens, because a couple of years later, Polpharma applies for a marketing authorization for a generic version of Tecfidera. And it asks the European Medicines Agency whether its product is eligible. And the European Medicines Agency confirms that it is indeed eligible, but that it has to take into account the regulatory data protection for Tecfidera, which started to run on the 30th of January 2014. That is when the implementing decision granted the marketing authorization for Tecfidera. Polpharma nonetheless applies for a marketing authorization for its generic version, and the European Medicines Agency, as could be expected, rejects Polpharma's application at that point in time in 2018. In other words, 4 years after the implementing decision only. And it states, the European Medicines Agency, that the monoethyl fumarates and dimethyl fumarates are both active and are not the same active substance, that Tecfidera and Fumiderm do not belong to the same global marketing authorization, and that the regulatory data protection for Tecfidera has not yet expired. That is the contested decision of the European Medicines Agency. And on the 9th of October 2018, Polpharma therefore launches an application for annulment with the General Court. So let us first look to the substance of this decision. Now, I admit that substance in this case may not be the best choice of wording, given the entire discussion on new active substance. But that is the wording that also the General Court has used in its decision, so I will stick to it in this presentation. The General Court, first of all, discusses its scope of judicial review. It says that when an administrative authority has taken a decision which results from complex technical assessments, there is a wide measure of discretion. And the General Court can only perform a limited judicial review. It can only look for inconsistency or into the statement of reasons. These are subject to judicial review. And there has to be a manifest error of assessment. Particularly, Polpharma has to provide evidence that which makes the factual assessment and the contested decision implausible. The General Court, for instance, cannot constitute or substitute its own assessment, and it has to look at the facts and the law that were available when the contested measure was adopted. Secondly, the General Court also looks to and discusses what is this global marketing authorization and what are the objectives. It says that there definitely has to be a balance between the innovative side and the generic side, both interests. And also an abridged procedure, the possibility of an abridged procedure, that serves the purpose of saving time and expenses and allows to gather results and use results from pharmacological and toxicological tests and clinical trials, whereby the repetition of further tests on humans or animals is avoided because, as such, they are not necessary. The General Court also explains that you can actually already obtain an extension with 1 year if you have a new therapeutic indication with a significant clinical benefit. So there's no need to kind of continue this ongoing new RDP one after another. Regulatory data protection cannot be extended indefinitely because it would not take into account the earlier discussed interests. And it also states that the scope of a global marketing authorization is irrelevant as to whether or not a new marketing authorization for a new therapeutic indication for a product with a new name has been granted. The global marketing authorization encompasses developments for which separate marketing authorizations have been granted, or at least it is possible that it encompasses such further marketing authorizations. What is then the legal assessment? What is relevant here according to the General Court? Well, the General Court says that in any event, the fact that a full application under Article 8.3, as submitted by Biogen, that is not key as to whether or not there is a new marketing authorization, whether it does not fall or does fall under the global marketing authorization. What is relevant is whether or not the monoethyl fumarate salts in the original combination product were clinically relevant, or whether they had a therapeutic effect in Fumaderm. Because by performing this assessment, you can know whether or not Fumaderm and Tecfidera belong to the same global marketing authorization. As I said before, this was at the point in time when Tecfidera, the marketing authorization for Tecfidera was granted. This was uncharted territory. At that point in time, it was the first time that the European institutions had to assess whether a combination product and a component of that combination belonged to the same global marketing authorization. And there were no legally binding provisions with clear and precise conditions as to what should be examined in these types of cases. As a result of this case, there were afterwards provisions were changed to deal with these types of issues. For instance, for the first time in the notice to applicants of July 2015. The General Court also discussed the long period of 15 years between the marketing authorization for Fumaderm and the application for Tecfidera, because in this long time of 15 years, it considered rules had changed. When Fumaderm was granted and the marketing authorization for Fumaderm was granted as a marketing authorization for a combination product, well, at that point in time, the active substance, the term active substance was not yet defined. It was only defined afterwards. Also, scientific knowledge had changed. Most of Biogen's evidence that it had submitted also post-dated the marketing authorization for Fumaderm. So, in the General Court's view, the Commission had been correct to reject the European Medicines Agency's initial approach that an authorization for a combination product, as a matter of principle, would be regarded as a global marketing authorization. And it also was correct to request the committee to assess and reassess whether dimethyl fumarate differed from the combination product Fumaderm. The General Court also looked into one of the arguments of the European Medicines Agency, Commission and Biogen, which was the mutual recognition of the German Drugs Agency's decision. And it's admitted, yes, mutual recognition is key. It's key to avoid that each member state puts an additional layer on layer after an assessment on marketing authorization has already been done by one of the member states. But it applies particularly to the decentralized procedure it considers. It does not particularly apply to the centralized procedure. And that is in the view of the General Court because, first of all, the European Medicines Agency and the European Commission have this kind of separate and higher authority. They perform a particular function that is not comparable to that of the national authorities. And in particular, this case, this question here, as to whether or not Tecfidera was covered by the same global marketing authorization, that was of particular interest of the European Union and therefore the responsibility of the Commission and the European Medicines Agency. So the Commission, the General Court also refers to the Commission's conduct during the entire procedure, which I discussed before. The Commission asking the European Medicines Agency to reassess, which from the viewpoint of the General Court confirms that there should not be just mutual recognition of the earlier German drug agency's decision. As a result of that, the General Court states, well, the committee, the European Medicines Agency's committee could, and actually you should read should, carry out a new scientific assessment of Fumaderm, or at least ask the German drugs agency for the necessary information to verify the German drug agency's assessment. And it did not do this. So the General Court, on the basis of these earlier conclusions, turns to the factual data, the data and the factual assessment. And it considers that the documents on which was relied do not provide relevant and sufficient data concerning the clinical activity of the monoethyl fumarates in isolation. And it refers to the rapporteur's joint report. It also states that the clinical studies examined by the committee did not support that the effects of administering DMF, dimethyl fumarate, in combination with monoethyl fumarates are different from the effects of just administering dimethyl fumarates alone. And as a result of that, when the implementing decision of 30 January 2014 was adopted, the General Court concluded that the European Medicines Agency and the Commission had, or could have had, and should have had data capable of rendering implausible the theory that monoethyl fumarate played a role within Fumaderm. But they didn't have this information. So the conclusion in the General Court's view is that there was a risk that Biogen would obtain or would have obtained a regulatory data protection solely because it had put on the market a new product in which one or a couple of active ingredients were removed and another one was kept, without knowing whether or not the removed active ingredients, the monoethyl fumarate salts, were clinically relevant, or whether the dose of these the monoethyl fumarates in Fumaderm was too low to produce any significant therapeutic effect. So granting new regulatory data protection under these circumstances and in the absence of a proper assessment by the European Medicines Agency and the European Commission would run contrary to the objectives of a fair balance and of the abridged procedure. As a result of that, it concludes that the implementing decision of 30th of January 2014 is based on a manifest error of assessment. It violates the principle of sound administration, and it should therefore therefore be held inapplicable regarding the fact that Tecfidera did not belong to the same global marketing authorization as Fumaderm. I hope that was clear, and I will give the floor to Philippe to discuss a bit more of the procedure. Thank you very much.
Thank you. So apart from these interesting substantive elements that Kirian just discussed, this case is also interesting from a procedural point of view. So even if you don't like procedure in general, please stick around. More particularly, the case offers interesting insights into the procedural or strategic options that you need to take when you wish to contest the validity of a measure when the procedural timeline for doing so has already expired. And secondly, it also goes to show the type of procedural acrobatics that you must take recourse to in the extremely rigid standing and interesting requirements that were set out by the European Court of Justice. So as a brief reminder, in case reminding is necessary, there were two regulatory decisions at stake here. So first of all, there was the implementing decision of 2014, which I will further refer to as the implementing decision, which granted the second marketing authorization to Biogen for Tecfidera, and which was based on the finding, as Kirian explained, that Tecfidera merits its own marketing authorization separate from the one already applying to Fumaderm. So it was not covered by the same global marketing authorization, thereby triggering a new data protection term. And the second decision that is of relevance in this procedural context is the European Medicines Agency decision of 2018, which I will further refer to as the contested decision, just like the court did, which rejected Polpharma's application for the grant of a marketing authorization for a generic product of Tecfidera. And the sole basis of which was indeed the implementing decision, because the reason that the European Medicines Agency declared the application of Polpharma ineligible at that time for generic marketing authorization was indeed the fact that a separate data protection term existed for Tecfidera. So this led eventually to Polpharma introducing an annulment action before the General Court against the contested decision on the basis of Article 263 of the Treaty on the Functioning of the European Union, accompanied at the same time by a plea of illegality against the earlier 2014 implementing decision, and that was based on Article 277 of the Treaty on the Functioning of the European Union, effectively asking the court to render that implementing decision inapplicable. So the main procedural questions that essentially arose in this interesting procedural discussion were, first of all, well, is the 2014 implementing decision an act of general application, which is one of the requirements for the plea of illegality under Article 277 to succeed? And secondly, if it was, then why did Polpharma not act sooner against the implementing decision directly already back in 2014? And that is then the discussion under Article 263. So to dive into this, I've sort of reformulated Article 277 to make it a bit more readable for the purposes of this presentation. To start off with the plea of illegality, now what does Article 277 say? It says that notwithstanding the expiry of the procedural period laid down in Article 263 to start an annulment action, which is 2 months from publication, or if no publication happened, the notification or the knowledge, any party may plead the grounds that are specified in that article, which are the grounds that you see listed in the bullet. The one that interests us here is particularly the alleged violation by the European Commission of the infringement of rules of secondary law, the rules under the medicines legislation. And that party may plead those grounds in proceedings in which, according to Article 277, an act of general application adopted by an EU institution is at issue in order to invoke the inapplicability of that act. So that, in a nutshell, is what Article 277 says. So the first question, and the main question also that arose in the context of this decision, was, is this 2014 implementing decision, the one that granted marketing authorization to Biogen as a result of a bilateral procedure between the Commission and the applicant at the time, is that an act of general application? And the court here confirmed that formally it is not, because it's an individual decision, as I said, granting marketing authorization to a specific company. However, it reminded that to apply Article 277, you do not necessarily need to look at the form, because indeed a decision is the type of act that is usually used by the European institutions when it comes to measures addressed to a specific party, whereas a regulation would be the typical type of act that is used for a measure to have a general application. However, according to the court, the name is insufficient. You need to look at the purpose and the content of the measure. So here the court said, well, from the court's case law, it's become clear that for something to be of general application, the act in question needs to apply to objectively determined situations. And here the court said that is the case because the Commission came to the conclusion that indeed DMF differed, Tecfidera containing only DMF differed from Humiderm containing both DMF and MEF. So this is an objective finding about the characteristics of these two products. And in addition, the criterion applies that the measure in question must produce legal effects in respect of a category of person envisaged in a general and abstract manner. So here the court emphasized that there are legal effects, notably the triggering of a new period of data protection. And secondly, it is an open category of persons that is envisaged, notably any operator that has activities linked to Tecfidera, such as Polpharma, that wanted to introduce a generic product onto the market. So this arguably applies to any act which grants a proprietary right to an individual party, which is, of course, a very interesting finding. And indeed, on that basis, the General Court concluded that the implementing decision of 2014 produced similar effects as an act of general application and must therefore be considered as one. Now, the follow-up question in this regard is then, of course, if it is indeed an act of general application, then why was it not already attacked under Article 263? Because Article 263 itself allows to act against general acts of application. But first of all, before we dive into that, there is one more point I wish to highlight under Article 277 for the procedural lovers out there. Article 277 has again been emphasized in this case, is not an independent right of action. It only provides the right to challenge the validity of an act of general application incidentally. So here, this also meant, according to the General Court, that the decision or the measure in question does not have an erga omnes effect, meaning applying to everyone out there beyond the parties involved. It only entails the illegality of the individual contested measure and leaves the act of general application in place. Basically meaning if somebody else were to come along and say that they have been harmed by the implementing decision, they would have to challenge it over again and would not be able to benefit directly from the impact of this decision. So that means, according to the General Court, that Article 277 can therefore not be an independent head of claim. And this is apparently what was done or claimed in the present case, and which is in a way artificial, because the General Court confirms the general principle that it has the jurisdiction to declare an act of general application unlawful or inapplicable, but it cannot do so in the operative part of the decision. So basically you can raise it, but you cannot ask the court to declare it in the operative part of the decision, which is a bit artificial, but which is also why in this case, the first head of claim that was asked by Polpharma to declare the plea inadmissible and well-founded was in itself declared inadmissible. So this was just for the sake of completeness, but it does go to show for a first time already that the debate can sometimes be a little artificial. So, but then secondly, the question indeed arises under Article 263. Why did Polpharma not take action already against the decision of 2014 to grant marketing authorization to Biogen? For that, we first need to look into the legal criteria of Article 263. Now, Article 263, which deals with the possibility to file an annulment action, and also here I've kind of reformulated the article to make it clearer, states that any natural or legal person may institute proceedings against, first of all, an act addressed to that person, or if the act is not addressed to that person, which was the case here, it must either be an act which is of direct and individual concern to them, and particularly, and we will get to that, the notion of individual concern is often looked at as an insurmountable hurdle, and according to some, with the root cause of all evil, so to speak, for quite a lot of procedural complexity before the EU courts. Or the third option is, again, where the act is not addressed to that person, it must be a regulatory act which is of direct concern to them and does not entail implementing measures. You must raise that under the conditions that we've already discussed that are set out in Article 263. So the main question here was the implementing decision. Does it fall under any of the categories of Article 263? And the court analyzed each of these criteria. First of all, they said it's clear that it's not an act addressed to Polpharma. No, on the contrary, it was an act addressed to Biogen. Secondly, it says it is not an act of direct, particularly individual concern to Polpharma. And here we go into the very strict and rigid criteria that the court over the years has set for Article 263 to apply. Because, first of all, it must affect Polpharma by reason of certain attributes which are peculiar to it, or by reason of circumstances in which they are differentiated from all other persons. And it cannot, by virtue of these factors, it must distinguish Polpharma individually, just as it would have distinguished them in case the act would have been directly addressed to them. So as you can tell, this is a very high procedural hurdle. Here the court said, well, the marketing authorization is, the procedure to grant the marketing authorization is bilateral. So Polpharma's individual situation was not taken into consideration here, and therefore it cannot be considered as an act of individual concern to Polpharma. So finally, the only category that was left was to assess whether the implementing decision is a regulatory act not entailing implementing measures. The fact that it's a regulatory act is something that the court essentially already assessed under Article 277, because a regulatory act is essentially all non-legislative acts of general application. Legislative acts being those acts that are passed under the normal legislative procedure before the European Parliament and the Council. So this is a regulatory act, so that is clear. And the question then arises, does it entail implementing measure? And this is particularly the interesting part of the decision, because here the General Court emphasized, first of all, that the implementing decision only had legal effects on Polpharma through the contested decision, the 2018 decision that Polpharma itself had triggered. And it's only through that contested decision that Polpharma was able to establish that the implementing decision was capable of producing direct, concrete, and certain effects on its legal situation. In other words, Polpharma needed the contested decision in order to show that the implementing decision of 2014 indeed affected it. So according to the General Court, that means that the contested decision of 2018, whereby the generic marketing authorization was rejected for Polpharma, is in itself an implementing measure of the implementing decision. So an implementing measure of the marketing authorization for Biogen. So that means that it does entail implementing measures. So for that reason, Article 263 could not apply, and therefore, according to the General Court, Polpharma could not have acted already back in 2014. And for the sake of completeness, the General Court also emphasized that Polpharma in any event did not have an interest in directly challenging the implementing decision at that time, already back in 2014, because for there to be an interest under the case law of the European Court of Justice, the interest must be vested and current. It may not concern a future and hypothetical situation. And according to the General Court, that is the case where, like the situation of Polpharma back in 2014, for example, a generic manufacturer is only at the very early stage of development, it would mean that seeking annulment proceedings, seeking the annulment of the implementing decision at that time would not have been based on a vested and current but future interest. That is interesting and not in line with, for example, other areas of the law, such as patent law, what we're confronted with, where the many courts in many, at least continental jurisdictions, recognize that you have an interest to seek the annulment of a patent as soon as you have intentions to bring that product on the market. So this is different from a procedural angle under Article 263. So that brings me to the conclusion on the procedural part. So what can we conclude from this decision? Now, of course, it's an annulment action, meaning that it's very factual and very case specific, but nonetheless, the decision goes to show that it's very important to keep track of regulatory decisions that potentially affect your position. If you see that a marketing authorization is granted, which could potentially trigger new data protection, it's important to keep track of that. And if possible, if you're allowed to, because as we discussed, the procedural requirements are very strict, try to act in time. If you were not able to act in time because you do not meet the eligibility requirements of Article 263, you should already at that stage determine alternative strategies, explore alternative options at an early stage, whereby Article 277 offers a welcome tool, although it does require you to trigger a decision which has a root in the earlier act. And this is particularly interesting if you read that together with the finding of the General Court, and we will of course have to see whether that will be upheld on appeal, that the decision or any decision basically awarding a right to a grant to a third party, such as the right to indeed grant additional data protection to Biogen in this case, is considered to be an act of general application to the extent that it limits the rights of third parties, here precisely because of the extra data protection, preventing third parties from relying on the data in this case in 2018. However, more generally, I think the case, particularly for those who have an interest in procedure, the case highlights once again the tensions that exist in the often quite artificial nature of the procedural debate. For example, first of all, of course, the fact that the General Court has concluded that Polpharma did not have an interest in bringing an action in 2014 because the product development was still at an early stage, one can wonder whether that is truly the case. Now, of course, we need to take into account the existing procedural requirements set out by the Court of Justice, but as I said, in many other areas of the law, the situation would be different. Similarly, also in terms of standing and the notion of individual concern, the 2014 implementing decision was said not to individually concern Polpharma because it was a marketing authorization grant procedure, which is necessarily bilateral. And on that basis, and on the basis of its case law, the General Court said that it can therefore not be seen to adversely affect the specific rights of Polpharma. But then at the same time, the court under Article 277 nevertheless recognizes that the contested decision is an implementing measure of the implementing decision, which essentially still boils down to a recognition that the specific rights of Polpharma have been adversely affected by the earlier decision. So it's a bit artificial, and I think the court would only does this precisely because of the rigid requirements of Article 263. There are perhaps easier solutions possible. And finally, of course, as I said, the fact that you cannot declare in the operative part of the judgment that an act of general application is declared inapplicable also has a kind of artificial feel to it. So the solution would be probably to relax the procedural rules under Article 263. I don't think that will happen because many people, scholars, advocate generals have already called for that. But Article 263 is simply a useful procedural tool for the European courts, and perhaps quite understandably also to keep as many cases out as possible because they fear that otherwise they would be facing a flood of annulment actions if the standing requirements would be relaxed. So, as we already said, there is an appeal pending against this case before the European Court of Justice. There were 3 appeals filed, both by the European Medicines Agency, by the European Commission, and by Biogen. And basically, only Biogen still raises the procedural concerns. So they claim that Polpharma indeed could have challenged the Commission's decision of 2014 directly under and that therefore the plea of illegality should be declared inadmissible, whereas the other appellants mainly stick to the substantive arguments that were set out by Kirian, and so of course also does Biogen. So wait and see what happens. On a final note, please stay tuned for the next edition of our Life Sciences seminar or Life Sciences session. And coming up shortly in the near future is also the Pharma Law seminar. Invitations have been sent, so please feel free to register for that. That will be hosted by Kirian and Christoph Ronse on the 21st of April, and then later coming up, which will be hosted by myself, on the 17th of June will be our Agri-Food Law seminar. And of course, the decision that we discussed today has its impact on both topics.